May I please, my lords?
Yes.
My lords, I beg to mention, in item number 9, I have instructions to appear for respondent number 4, that is the Nagaland Lokayukta.
Nagaland Lokayukta.
My lord,
Item number 4.
item number 9
Item number 9.
for respondent number 4.
You are appearing for the first time today. You are appearing for the first time today.
Yes, yes, yes.
Worship,
Yes.
let's speak up. Respondent number 5 to 9.
Hmm.
I have instruction to appear also.
Okay.
For the appeal, your lordship.
Okay. You are for respondent number 4.
I'm for respondent number 4.
I'm for 5 to 9.
Okay. Heard the learned counsel, Mr. So-and-so appearing for the respondent number 4. He has entered his appearance for the first time today. Heard Mr. So-and-so appearing for the respondent number 5 to 9, who has also appeared for the first time today. Both the learned counsels praised for some time.
And for the appeal.
Ms. So-and-so appearing for the appellant. The prayer of the learned counsels.
My lords,
Yes,
the matter may be fixed for admission hearing after 2 weeks.
yes. After hearing the learned counsels both sides, the matter is adjourned today. Least up to 2 weeks for admission hearing.
Lordship, there is an interim.
The interim order past will continue until then.
Obliged, lordship.
Obliged.
Yeah, please, your lordship.
Yes.
I'd beg to mention item number 1 and 2 on behalf of my senior. Lordship, we have received copy of the affidavit filed on behalf of respondent 1, 2, and 3. However, we are waiting for further instructions from the petitioners.
Lordship, here in this case, it's the direction of the court. It's not the prayer of the petitioner. The court has made an observation on 13/3/1925, whether the adolescent friendly health clinic is functioning, the 38. So we have made an affidavit saying that it's functioning. So that was the query of the court, not the prayer of the petitioner.
Yes, yes. Somebody was directed to file an affidavit also.
Yes, I've already filed.
You have already filed.
Yes, we have already filed.
You have put a respondent number 4.
I'm for 1, 2, and 3.
1, 2, and 3.
Medical department, Lordship. So we have complied with the order of this honorable court. So what further instruction they need required, Lordship? Because that's observation of the court, not the prayer of the petitioner.
Lordship, in that case, my senior is indisposed. Kindly list next week.
Our senior is absent today.
Yes, lordship.
What is your name?
Loreno.
The learned counsel MS Loreno, appearing on behalf of Mr. K. Fuka.
Yes, your lordship. Appearing on behalf of Nitil Koza.
Oh, Nite Koja. Submits that Mr. Koja is indisposed today. And on that ground, an adjournment is paid for. Heard Mr. So-and-so, the learned.
Next week, Lordship.
The state respondents. The prayer for adjournment is allowed. List next week, along with item number 2.
Lordship. I also beg to mention item number 20.
20.
Yes. I'll be filing my affidavit today.
You have filed your affidavit
I'll be
today.
filing my affidavit today.
You will file or you have already filed?
I have not filed. I'll be filing today.
You will be filing today. You have for a respondent.
Yes, for the respondent union.
The learned counsel, Mr. So-and-so. The learned CGSC
Malus.
has submitted that he will be filing the counter affidavit during the course of the day. Heard MS
Okay, Lily Sue for the petition.
appearing for the petitioner. The prayer of the learned CGSC is allowed. Up to 2 weeks.
So you.
Okay, lordship will be needing some instructions, so kindly list this matter after 3 weeks, lordship.
Up to 3 weeks. At least up to 3 weeks.
I'll give you a copy of the.
May please, Lordship, Lordship, I beg to mention hearing item 21. I've taken the concern of the opposite party. Lordship, I pray that this matter may be listed after 3 weeks.
Up to 3 weeks, okay. The learned counsel MS so-and-so, appearing for the respondent. You are for the respondent.
I'm for the appellant.
Appearing for the appellant. prays for an adjournment and also submits that she has already informed the other side. Accordingly, the hearing is adjourned today. When do you want it?
After 3 weeks.
At least up to 3 weeks for hearing.
Okay. Much appreciated.
May I please, Your Lordship, I beg to mention item number 3. I'm appearing on behalf of my senior, Nita Okoza, counsel for the petitioner. Your Lordship, we have received the affidavit filed by the respondent 1, 2, 3, and 4 this morning. So sometime we wanted to seek further instruction.
Lordship, here also it was a query of the court.
Ah,
Yes. Because their prayer is becoming like a tree. It's growing
yes.
every time.
The rejoinder was to be filed probably.
No, Lordship, now the court has made a query whether the blood centers in the state are adequate to meet to the requirement. So we are saying yes. Until date, we have no complaint as such with regard to any death with shortage of blood.
Yes.
We have the linkage system, Lordship. So if any private hospital also need, we give them the blood. Next week, Lordship, if the senior is not present. here
Okay.
today, Lordship.
MS.
Abi.
Appearing for the petitioner submits that she has received the affidavit filed by the respondent today and therefore prays for some time to receive instructions. I have also heard Mr. So-and-so, the learned counsel appearing for the respondents. The prayer of the petitioner is allowed. List next week.
Much obliged.
May I please, Your Lordships?
Yes.
I beg to mention item 18 and 19 on behalf of the counsel for the petitioner.
18, 19 is the listed.
17, 18 and 19.
17, 18 and 19.
Yes, Lordship.
Yes.
As the counsel for the petitioner is on bereavement, kindly list the matter on 13th of November. I've taken a counsel from the other counsel,
So, who is the council?
19.
Bereavement?
19th of November.
Okay. No, who is the council?
The counsel is Apila Sanctum.
Pillar Sanctum. What is your name?
Autumn Jinjamir.
The learned counsel, Mr. So-and-so. Appearing for the petitioner submits that the learned counsel, conducting counsel, Mr. Opila
Sanctum.
Sanctum is in bereavement. And on that ground, an adjournment has been prayed for. I have also heard the learned counsel put a respondent. The prayer for adjournment is allowed. List after 2 weeks,
19th of November.
list on 19th of November, along with item number 18 and 19.
Plus, Your Lordship, 17 also maybe, can you be included?
17.
Yes, all this.
No, we have passed the order in 17. You can-
Yes, sir, Governor.
From the supplementary cost list for motion, item number 22.
Yes.
May I please, Lordship. I humbly submitted the petitioner by filing the instant habeas corpus petition is issuing the detention order dated 5/6/2025 and the confirmation order dated 19/6/2025.
Okay, today we will issue notice only. Today we will issue notice.
Your Lordship,
Yes.
if I may, the petition, Your Lordship, is defective in nature. The petitioner, who's the detainee himself, at page number 25, the affidavit, since he's lodged at the central jail, the affidavit should have been routed through the jailer, Your Lordship, but this was not done so.
My lord, in that regard, I humbly submitted the notary himself have went to the jail and taken a signature, the president of the jail official. And in the Vakalatnama, the jailer have countersigned in the Vakalatnama.
In the Vakalatnama, jailer is countersigned.
Yes, my lord. So there is no issue of
Heard Mr. So-and-so, appearing for a petitioner. Heard MS So-and-so, appearing for You are appearing for all the respondents.
Yes.
Four.
Uh,
Respondent number 4.
Heard Mr. So-and-so appearing for the respondent number 4. Issue notice. No formal notice is required to be sent to the respondents. As because the learned counsels appearing on behalf of the respondents have accepted notice. Extra copy of the petition shall be provided to them. Least up to 2 weeks for admission hearing.
You're highly obliged. For admission, item number 4.
Who was to file the affidavit? Respondent number
The-
4.
Yes,
Five.
5, respondent number 5.
Oh, yes. Affidavit filed or not?
May I please your lordship?
Yes.
If your lordship may allow pass over for the time, our leading counsel is coming from Gauhati, so he will be reaching soon.
Okay, all right.
No, but you were supposed to file an affidavit before 13th.
Yes,
Oh, no, before 13th. Has that
13th.
been filed?
they have not complied with lordship. That's the issue. Now, lordship, this is pertaining to non-release of the claims by the insurance company.
Yes.
So they were given a specific direction to file an affidavit to as to how much claim has been released and which are pending. Now, as per our record, lordship, they are yet to clear the claims of more than 30 crore.
Acha.
Lordship, it's a huge liability.
Okay, who is coming? A Kakoti.
Abhijit,
Okay. When he will come?
He's on his way.
yes, on his way, he's stuck in traffic.
Okay, after some time. then-
After some time.
For admission, item number 5.
May it please your lordships.
Yes.
Lordships, challenging this detention order,
Hmm.
mainly on the ground that material documents which were vital
Hmm.
were suppressed. Secondly, that there has been non-application of mind by the detaining authority while passing the order. Thirdly, that materials in the vernacular of the détenu were not furnished to him. And
Okay, do you want to file any reply in respect of the affidavit in opposition filed by the respondents?
no, your lordship.
Then it will go for hearing.
Admission hearing, your
Admission
lordship. In fact, this matter has been listed for admission hearing today, your lordships.
It will go for hearing. Heard, Mr.
Kohima, your lord.
Give me appearing for the petitioner. Heard. The learned CGSC, Mr. So-and-so. Appearing for. The. Respondent number 4. Heard Mr. So-and-so appearing for the state respondents. List this matter for hearing. After 2 weeks,
Your lordship, next week.
next week.
For admission, item number 6.
Yes.
May I please your lordships? The present appeal is directed against the ungiven judgment and order dated 9/9/2025, passed in series of cases. As many as 13 cases were taken up together. And since the inquiry was conducted in the same manner, so it was felt appropriate to take up all the cases together. So the entire matter was taken up and a common judgment was passed.
Yes.
We are concerned with WPC 114 of 2022. I was the counsel for about 6 cases,
Yes.
but then other petitioners, they have accepted the judgment. But this is a peculiar case and different from others. So the present appellant is the only person who is approaching this honorable court questioning the judgment and order passed on 9/9/2025, Lordship. The learned single judge, while passing the judgment, has relied on few judgments which were totally opposite to the present case in hand because of the fact that the facts are totally different. The ratio laid down in those cases are passed in a cases where the initial appointment was illegal. And the certificates which they were holding was also fake. On the basis of that, with that certificates, they joined the services. Therefore, even if the opportunity is afforded to the petitioner, it will be of no help. It will be an empty formality only. Therefore, it is not necessary to afford opportunity of being heard. So the principle of natural justice, even if it is not followed, it will be of no consequence. That was the principle laid down in those cases. Whereas in this particular case, the petitioner was appointed on the basis of an open advertisement, and she was appointed on the basis of that advertisement. And since it was required to obtain additional qualification, since it is the teaching post, they should acquire P8 qualification.
Yes.
So she has given an undertaking to obtain within a period of 3 years. And like me, all the candidates were given that because many of them were not possessing that P8 qualification. Otherwise, I'm MCOM and then appointed as a graduate teacher maths. So I have undertook that, and then I have enrolled in Isaac Newton School for undergoing P8 training, and which happens to be affiliated to Digboy College, which is under Devonport University. The department has approved Devonport University to impart P8 training. So the petitioner has enrolled, but the petitioner did not know that the Digboy College was not imparting training of P8. But Isaac Newton School, like any other teacher, they have been imparting training. I would like to take your lordship's attention to page 92. This is a letter by the NCET. National Council for Teachers Education. This was issued on 26 February 2020. I will read the first paragraph only. Whereas Digboy P8 College, care of the Little Star School, Purple No. 1, Digboy, Tinsukia, Assam, was granted recognition for P8 course with an intake of 100 ERCs ordered to the so-and-so 7/9/2005, followed by revised recognition order of White 32107 dated 26/5/2015 with an intake of 100 from the academic session 2015-16. Petitioner appealed in 2015, Lordship. As per NCET regulations 2014, subject to fulfillment of the conditions in respect of enhancement of additional build-up area, additional infrastructure, additional fund, additional staff, maintain and update website, and to comply with the same to the ERC. So this is an official publication by the NCET, and Isaac Newton School, from where the petitioner obtained the P8 certificate, has been affiliated to Tikvoi College, Lordship. And during this time, the government has approved to undergo P8 from Isaac Newton School. Kindly come to page 132. Page 132. Has your lordships got it?
Yes.
Page 132, this is 14/4/2022. To whom it may concern, issued by the Isaac Newton School. This is to certify that Miss Alila Emsong, that is the appellant, had availed P8 course for the academic year 2014-15 from Tikpui P8 College under Deborah University through distance mode from Isaac Newton School, branch code number so-and-so, Simatila, Dimapur, as the study and exam center under the mentorship of late Naresh Sinha, who was the principal of this institute under whom B8 courses through distance mode were being offered. In this regard, the institute certifies that all students, including state government teachers, this is very important, including state government teachers who came for availing distance mode B8 courses had been availing under the mentorship of late Mr. Naresh Sinha. Hence, up to the untimely demise of our 10th principal, late Mr. Naresh Sinha in the year 2020, the Isaac Newton School, Dimapur, no longer provide distant B8 courses. So from this certificate, Lordship can find that it is not only Alila Emsong who is the appellant,
Some others
but
also did.
others were also availed from this institute. And we did not have the knowledge that this institute is not affiliated nor recognized by UGC. So innocently, I have availed, enrolled, and then obtained a P8 certificate. And this point I could have raised during the inquiry if opportunity is afforded to us. Because the writ petition, the main thrust in the writ petition was, look, an inquiry was conducted so as to ascertain whether it is genuine or not, all this. A common inquiry was conducted. So since there are many people, maybe they wanted to do it in a shortcut manner. So what they did, the inquiry, during the inquiry, they have only given a questionnaire. You respond to this, whether yes or no, bas. Thereafter, we were not heard in person. No documents were furnished. Therefore, there is violation of principles of natural justice, which is the mandate of law in an inquiry, more particularly when the penalty to be imposed is major. And it will have far-reaching consequences also. Lordships are well aware that it is a must that in any inquiry, roll up auti alteram padam. Natural hearing, fair hearing is a must and it's a mandatory requirement. The learned single judge, while is heading the case, because that was the main thrust in the writ petition, the learned single judge, with due respect, he arrived to a conclusion that yes, inquiry was not followed and natural justice was not followed. There is some violation on procedural aspects, but even if I afford the opportunity of being heard, it will be of no help to them. It will be an empty formality because they lack the basic qualification. Here, the problem lies basic qualification. Those cases which the learned single judge has relied upon and referred to in the case to decide our case is, those are the cases where the petitioners were not possessing requisite and basic qualification. But in the present case, there was no doubt. It was an open advertisement. Basic qualification was there. I'm MCOM. But additional qualification, this cannot be treated as basic qualification. In those cases which the learned single judge has referred to are the cases where the candidates were not possessing the basic qualification, but with the fake certificate they joined. Therefore, no, and they have admitted that also. So even if opportunity is afforded to them, it will be of no consequence because they have admitted and this are fact. And you don't have the basic qualification. But in our case, in my case, I have basic qualification. Therefore, the ratio which has been applied by the learned single judge so as to decide my case is misapplied, with due respect, lordships. That is how I'm before this honorable court. Now kindly come to the judgment, how the learned single judge has decided. It starts from page 137, but then the relevant portion which I'm referring starts from page 163, sorry. I will refer to 5 paragraphs, the operative portion of the judgment. And this is the basis of the order passed by the learned single judge.
Yes.
Paragraph from 21, may I read, lordships? The Division Bench of Patna High Court, in case of State of Bihar and others versus Kamlesh Kumar, reported in so-and-so, has observed that the courts have discarded the principles of natural justice when satisfied that the outcome of the case ought not have been different had the principles of natural justice been followed or observed. 22. In the case of S.L. Gabor versus Jogmohan, AIR so-and-so, the Supreme Court of India has laid down that if upon admitted or undisputable facts, only one conclusion was possible. Undisputable facts, this is relevant, lordship. Only one conclusion was possible, then in such a case, the principle that breach of natural justice was in itself prejudice ought not apply. In other words, if no other conclusion was possible on admitted or undisputable facts, this is also equally important. It will not be necessary to quash an order which was passed in violation of natural justice. 23. In the case of Aligarh Muslim University and others versus Mansoor Ali Khan, AIR 2000, Supreme Court 2783, the Supreme Court of India had considered whether on the facts of the case, the employee can invoke the principles of natural justice and whether it was a case where, even if notice had been given, result ought not have been different and whether it could be said that no prejudice was caused to him. If on the admitted or proved facts granted of an opportunity ought not have made any difference, it was observed. It will be sufficient for the purpose of the case of Mr. Mansoor Ali Khan as to show that his case will fall within the exceptions stated by Jenaparity J in S.L. Gabor Sabra, namely that on the admitted or undisputable facts, only one view is possible. In that event, no prejudice can be said to have been caused to Mr. Mansoor Ali Khan through notice, though notice was not been served. 24. In the case of Muhammad Sartaj versus State of UP AIR so-and-so, after considering a number of its earlier decisions, made the following observation with regard to the requirement of giving notice. In the present case, appellant's case fall within the exception laid down in S.L. Kapoor's case and other supporting cases, as admittedly the appellants were not qualified and they did not possess PTC or Hindustani teacher certificate or teacher certificate or certificate of training or certificate of any other training courses recognized by the state government as equivalent thereto at the time of their initial appointment. See, initial appointment, they were not qualified, those persons. Hence, the appellants did not hold any right over the post and therefore no hearing was required before the cancellation of their services. In the present case, the cancellation order has been issued with a very short span of time, giving no probability for any legitimate expectation to the appellants regarding continuation of their service. There was no separate appointment order issued in favor of the appellants, but the memorandum dated 19/6/85, wherein the list of selected candidates was published, provided that all the selected candidates must join their respective schools, colleges within 15 days from this. The nature of appointment made cannot be ascertained. Moreover, the cancellation order itself gives an opportunity that if they do not hold and possess the PTC qualification along with intermediate qualification, they can take and get the same verified on 14/8/85 by the appointing authority, and they may bring this to the notice of the concerned authorities. The copy of the order of cancellation was also sent to the principal concerned of the institution with the remarks that he should relieve O2 teacher with immediate effect if he did not possess the certificate of passing the examination of intermediate and PTC, and if he possesses these certificates, he should submit the same to the office of the district basic education officer, Muzaffarnagar. Therefore, it is apparent that any person having the basic qualification for the appointment can produce it before the concerned official so that immediate steps can be taken with regard to the order of appointment cancellation. In our opinion, on the above facts, no prejudice has been caused to the appellant by not serving notice of giving hearing before the order of cancellation was issued. Let me complete the judgment. Paragraph 25. In this batch of writ petitions, the authorities whose educational certificates that were relied upon by the petitioners have been declared to be fake. Thus, those documents ought not entitle the petitioner to be appointed in the first place. See, the learned single judge is talking about the initial appointment. Therefore, when the petitioners were not qualified and did not possess degree, diploma in education, and had submitted fake degrees, they lacked basic qualification, and the petitioners could not have been appointed, nor their appointment could have been continued. Therefore, in the opinion of the court, upon the above facts, no perceivable prejudice has been caused to the petitioners, although the inquiry proceedings were not strictly in accordance with the settled law. Therefore, the single judge has arrived to a conclusion that yes, inquiry was not conducted in accordance with law. When it is found that it is not conducted in accordance with law, the entire inquiry stands vitiated. Law is very clear on that, Lordship. And the rulings, all the rulings, judgments, which the learned single judge has referred to, is on the basic qualification, which those people did not have in those cases. Whereas we have the basic qualification, only the issue is with regard to the additional qualification. That is the PET, which I taught the institute to be a genuine one and enroll. And the government has approved. One very interesting development took place in the month of April 2025. This year, the Department of School Education has issued a confirmation, service confirmation order. In that order, the petitioner's name is also included as confirmed in view of satisfied service. I will furnish that order also, Lordships. But I obtained this order only after the writ petition was also disposed of. Because writ petition was disposed of on 9/9/2025, and this order is of April 2025. And before this, another candidate who was similarly appointed in the same manner, like that of the petitioner, on the basis of the same advertisement, date of appointment is also same. One Ausanla Pona. In her case, the disciplinary proceeding was quashed, and the disciplinary authority was directed to conduct a fresh inquiry, and they have done also. They have accepted the judgment and done. Same thing. That was also pointed out during the course of hearing. So, squarely governed by that case, nothing stops the government to go for a fresh inquiry. But at least I should be afforded an opportunity of being heard. I just want that, Lordships. Before the learned single judge, that was my plea.
Okay, today we will admit the appeal.
Lordship.
Heard the learned senior counsel, Mr. C.T. Jamir, assisted by Mr. Appeal for the appellant, heard Mr. Ayan Angami. The learned senior government advocate, senior government.
Yes, my lord.
Appealing for the respondents
1, 2, and 3, my lord.
1, 2, and 3. Issue notice. The 1, 2, and 3. The appeal is admitted for hearing. Issue notice. No formal notice is required to be sent to the respondents 1, 2, and 3 as because Mr. Angami has accepted notice. Extra copy of the memo of appeal shall be provided to him. The appellant shall take steps for service of notice upon the respondents 4 and 5 by registered postage AD.
Yes.
List after 4 weeks.
I'm deeply
So
obliged.
if, I have filed an IA, but it is not shown in the cost list, but I believe the file is there. On the strength of the
Yeah.
interim order, which
I-
was passed,
The IA is listed.
IA is not listed, but
Not
I think it is enclosed along with the file. Maybe the office
Yes.
may have overlooked to get it listed.
Then I will give a date.
Lordship, interim order was passed on 20th June 2022.
Hmm.
On the strength of the interim order, till the date of judgment, that is 9/9/2025, the appellant served in the post.
This IA is for what? For stay.
Yes. Since Lordship is admitting the appeal, I pray that the stay application may be considered
Okay, then I will
because
order here.
it will have adverse effect input in respect of the appellant as well as the state because they'll be deprived of the teacher.
Then you
The students will be deprived.
till returnable date.
Lordship, as far as the stay is concerned, Lordship, I have some objections there, Lordship. If along with this appeal, if notice can be issued in both the case, and then after 4 weeks,
But this IA is not listed today.
no, it is not listed today, Your Lordship.
It's a middle of academic session. So Lordship may
नहीं,
Suspend.
List after 4 weeks, till returnable date. The impugned judgment dated 09/09/2025 passed in writ WPC.
Lordship,
114.
if I may, Your Lordship, without listing the IA today, passing an order on the IA which has not been listed,
I
Your
have
Lordship,
served a copy, Lordship.
which has not been listed, Your Lordship.
But
It has not been listed today.
in the main case also, the prayer, interim prayer is there.
Yes, but in the interim prayer is so through an IA.
No, I will stay the judgment today till returnable date.
Lordship.
WPC number 114 of 2022 shall remain state till returnable date.
Obliged.
For admission, item number 7.
Yes.
My British Lordships, the IA 110 of 2025 is for continuation of delay of 197 days in filing the incident appeal.
The notice will go today. Today will be.
Lordship, I have instruction on behalf, to appear on behalf of this whole respondent, Lordship.
Oh, you have already appeared.
Yes, Lordship.
You want to take instructions?
I have no objection if the delay is confirmed, Lordship.
Okay, then. If there is no. Mr.
N. Kumar.
N. Kumar, appearing for the petitioner. Mr. Muajamir,
Lordship.
the learned counsel appearing for the sole respondent. Para. This application has been filed under Section 5 of the Limitation Act, praying for continuation of 197 days of delay in filing the writ fee. Para. Mr. Jamir has submitted that he has no objection if the delay is condoned. We have considered the submissions made by the learned counsels of both sides. The delay has been satisfactorily explained. Moreover, since Mr. Jamir has submitted that he has no objection if the delay is condoned, accordingly the delay stands condoned. The connected writ appeal shall be registered and listed for admission hearing. The ISS disposed of accordingly.
For admission, item number 4.
Yeah, please. Lordship, apologies. Actually, I was stuck in a traffic, Lordship. I am for respondent number 5. Lordship, in this matter, there was a direction by this honorable court to pay all the amount to the.
No, you were directed to file an affidavit.
Affidavit, correct, Lordship. I am coming to that, Lordship. Lordship, this is a very huge exercise. We have taken time once from this honorable court on the last occasion also seeking an extension. Today, Lordship, I have the instruction.
If you want, we can give more time.
Yes, Lordship, we need some more time, Lordship, but we want a direction from this honorable court, Lordship. Basically, what happened, Lordship, on 24 September, a meeting was held between the insurance company, the government, IRDA in Delhi, Lordship. So it was decided that we have to procure no due certificate from the hospitals. Accordingly, we are in the process of procuring no due certificate from the respective hospitals. We have procured some and few are remaining. In the meantime, private respondent number 6, that is the private Nagaland Private Doctors Association, they have shot one letter to us asking us not to approach the hospitals first. We have to go through them. That is in violation to the meeting which we have held with the government also, Lordship. So right now they are coming in between. So if a direction may be passed that whatever it was considered in the meeting between the government and the private insurance company and before the IRDA, so let it be done so that we can complete the process, make the complete payment and close the case, Lordship.
Lordship, the issue is there's an MOU signed between the insurance company and the state health authority. There's a procedure laid down. How the claim should be recovered by the hospital, by the insurance to the hospital. We are the stakeholders, Lordship. We pay the premium to the insurance company. Now, the problem started when the insurance company started rejecting the claims. The liability went up to more than 180 CR. 180 CR. They have cleared almost 150 CR. Around 30 CR is still pending. So what is stopping the insurance company from paying the claims? And there's a policy, there's a procedure where if there's any fraud detected, we have given an undertaking also that we'll recover for that. Their duty is to clear the claim. Now, Lordship, in the last order, this court has directed the respondent number 5 that they should file an affidavit giving in detail of the payment, the claims made to each and every individual hospital. Because the hospitals are not aware for what claim they have been paid also. They have the data with them. We have our data, Lordship. There were some issues with regard to not showing the claims in the database, Lordship. That has been resolved. Still, they are
right now,
making payment. No, they are filing the affidavit.
As was discussed with the government itself, Lordship. So we should get the no due certificate from the hospitals and submit it to them, and they will give us the final clearance. So right now, Lordship, we have taken no dues clearance from almost 23 hospitals and only 11 are remaining. So for that, we need some time, and let us present the no due certificate to the government so that government give us clearance and everything of the claim will be settled, Lordship. So give us some more time. We will comply, Lordship. But in the meantime, this respondent number 6 should not disturb us. That is a direction I request from this honorable court, Lordship.
Okay, already you collect. Then you collect from the remaining 11 hospitals.
Lordship.
Mr. A. Kakuti, the learned counsel appearing on behalf of the respondent number 5, submits that the insurance company has already collected no dues reports from 23 hospitals till now, and 11 hospitals remain. According to Mr. Kakuti, the respondent number 6, Private Doctors Association is respondent number 6.
6, Lordship.
According to Mr. Kakuti, respondent number 6 is written in later.
Lordship, if I may indulge, Lordship. Lordship, can you see the subject? Strong objection to unjust negotiation. So apparently this insurance company is going and negotiating with the private hospital.
Lordship, we have to get the no due certificate. So since some payments are due, hospitals are not inclined to give us the no due certificate since some time had elapsed. That's why,
so
as was discussed with the meeting, we have approved
they cannot negotiate with the private hospital.
We are not negotiating, Lordship. We are procuring the no due certificate.
The letter itself is speaking.
Yes.
They are negotiating.
Lordship,
we are the one who paid the premium to them.
Doctors Association is not a party to the meeting that was held on 24th September in Delhi with the government.
But the letter speaks differently. They are negotiating without our knowledge.
For reduced settlement amounts.
Yes. How can the
At this
insurance
stage, you
company go
cannot
and
have any,
settle with the-
at this stage, you cannot have any settlement.
They can
We only have to
You-
procure the no due certificate.
You
Lordship.
just collect the no due certificate.
Will and submit to the
But
government.
they should be restricted from negotiating with the hospitals, Lordship.
Yes.
Because unless we are aware of this, they cannot.
Lordship may record to that effect.
According to Mr. Kakoti, only 11 hospitals are left for collecting no dues certificates. You for respondent number 4.
4. No, 4.
No, 5.
5.
Five.
FGI is 5.
FGI.
5 for 4.
You for 4.
Yes.
The learned counsel, Mr. So-and-so, appearing for the respondent number 4, has submitted that the respondent number 5 should not negotiate in any manner with the hospitals.
In view of this, the letter.
In view of the letter written by the respondent number 6
Yes. On
on
9th October.
9th October 2025. But I have considered a submission, we have considered the submissions made by the learned counsels of both sides. The respondent number 5 is directed to procure the no dues certificate from the remaining 11 hospitals. And after that, the detailed affidavit shall be filed.
Yes. And also not to negotiate, Lordship, if they have been.
The respondent number 5 shall not have any negotiations with the hospitals. Least after 4 weeks.
Lordship, any date may be given specified because I have to come down from Gauhati, Lordship. Any date.
Then you, after 4 weeks, you suggest one date.
Give a date.
After 4 weeks. Huh?
Which one? Lordship, next week, because the 3rd November, 2 of November.
2nd November is a holiday.
12 is fine, Lordship. 12 November is fine.
Okay, list on 12 November.
Obliged.
For orders, item number 8.
Hey, please, your lordships. Service report upon respondent number 2 has come, so I may be allowed to hand it over.
So who is for respondent, the private respondent? Notice that we will appoint one amicus curiae. Do you have any list of amicus curiae? In the I heard MS so-and-so appearing for the applicant. Hired MS, you are additional public prosecutor.
I'm PP here.
Oh, you're PP.
Yes.
Who is for the applicant? You are for the
Yes, Lordship, I'm for the applicant.
hired MS so-and-so appearing for the applicant. Hired MS so-and-so, the landed public prosecutor. The notice upon the respondent number 2 is already served. And none appears for him. Therefore, you suggest an advocate name to be amicus curiae.
Yes.
You will work as amicus curiae.
For respondent to. I'm part of the panel, legal aid panel. So
Oh,
you
the
can-
legal aid panel is there.
Yes.
Your name is there.
Yes, ma'am.
Therefore, MS so-and-so, the learned legal aid counsel is appointed the amicus curiae to represent the respondent number 2. This is bail application,
Bail is there, IA is there for condonation.
This is for condonation.
condonation of delay.
Yes.
Condonation of delay for 235 days, Lordship.
Okay, you go through it, amicus curiae, you go through it, then reply. List next week. I will give you a date. You suggest one date. next week.
Twenty-second.
22nd, 22nd.
Okay, Lord.
Can it be on the 29th, my lord?
Okay, on 29th, 29 October.
I maybe serve a copy of the.
A copy of the interlocutory application shall be provided to MS Swens.
Much obliged.
For orders, item number 10.
Yes.
My lord, the sole respondent, who is the petitioner, she so the
Notice served or not upon respondent number 1?
My lord, I'm a prairie. So I may be allowed to appear on behalf of the respondent through her son.
Yes, sir. You will be appearing for respondent number 1.
Yes,
Respondent number 1 passed away.
pass away,
Oh, passed away.
my lord.
So what will happen now?
My lord, if the
Her legal heirs?
legal heirs, yes, the son, there was a gap here. What happened is this. When I was informed about the death, I told them to get the succession certificate in submitting to the authority. Then what happened is that they have gone to the commissioner office without any representation or application. So what the office said is that since it was, the court order is by the name of the deceased, it'll be processed in that manner. So just to keep it, that is how it was again. So for that, we both are equally guilty of that. Otherwise, the commissioner office should have informed the counsel or the petitioner. Of course, I didn't submit application or representation. That is, I am guilty of that.
Her legal heir is her son.
My lord, that is, yes.
He can be impleted in her place.
My lord, that is,
You implead him.
just make it as legal, true legal representative. So it can be disposed of next.
Okay. You take instructions so that they are interested in contesting.
My lord, they come and contacted me. Everything is entrusted to me.
Oh,
so what I'm saying is that if your lordship can call for the record of the writ petition, because here the whole trust of my learned friend is about the particular nomenclature, that is contingency period of a certain years.
Yes.
Whereas the learned single judge have clearly dealt with Rule 13. I've submitted my book list rulings in the writ proceeding about primacy, which is Supreme Court. So even if it is not reflected in the judgment, the learned single judge was clear about primacy ruling. So it can be disposed of in the next hearing, next listing.
Okay. Okay, then the learned counsel, Mr. So-and-so, appearing for the respondent number 1 submits that the respondent number 1 has expired on 10/03/2024 and her son will be impleted in her place.
My lord, as LR. True LR.
So, registry is directed to make the corrections in the title page of the memo of appeal.
next week you are not free. Then
Heard MS Suenso, the Learned Counsel appearing for the appellants. Who is for the respondent number 2, Accountant General?
Accountant General,
You are appearing.
no, in my writ petition, Accountant General is a party respondent. That is why they have to make it. as-
Performer respondent.
Yes.
Respondent. Heard MS Suenso appearing for the performer respondent. After correction of the title page of the memo of appeal, this appeal shall be listed after 2 weeks,
After 3 weeks.
after 3 weeks for hearing.
Malo,
Much obliged.
much obliged.
For orders, item number 11.
Please, Lordships.
Yes.
Lordship, the IAs for continuation of 1,181 days of delay in preferring the appeal.
But notice has to be sent to the
Yes,
respondent number
Lordship.
2.
Yes, Lordship.
Heard Mr. Muajami, the Learned Counsel appearing for the applicant. Heard Mr.
KM, Lordship.
KMN appearing, the Learned
Respondent
public
number
prosecutor for the respondent number 1. Issue notice. No formal notice is required to be sent to the respondent number 1 as because Mr. So-and-so has accepted notice. The applicant shall take steps for service of notice upon the respondent number 2. How you send the notice? To the concerned police station,
Lordship.
through the concerned police station. Then the notice will be issued through the registry to be routed through the office of the public prosecutor. Least after 4 weeks.
Obliged.
For orders, item number 12.
Lordship, even in this case, the IAs for continuation of 485 days, Lordship.
This is also POCSO.
Yes, Lordship.
Then make the same order. Say same order.
Lordship.
For orders, item number 13.
Lordship, this is also POCSO, but there are some clerical mistake in the IA as well as in the appeal, if I may be allowed to withdraw, Lordship.
You want to withdraw the appeal?
Lordship.
Mr. Muajami, the Learned Counsel appeal for the appellant submits that there are some errors in the appeal, in the memo of appeal. Therefore, he has instructions to withdraw the appeal for the time being.
Lordship.
Heard Mr. So-and-so, the Learned Public Prosecutor for the state of Assam. The appeal stands disposed of on withdrawal. You will file it again.
Lordship.
Liberty is given to file the appeal afresh.
Lordship. Much obliged, Lordship.
For orders, item numbers 14 and 15.
May please, Your Lordship.
Yes.
Leadership. Lordship, the IAA is for leave to appeal. No, leave to appeal, Your Lordship.
So you were not party.
We were not parties, though we were affected. The impugned order affects us, we were not impleaded as parties. So the IAA is for leave to appeal, Your Lordship.
Heard Mr. A. Jimoni. The Learned Counsel appearing for the applicant. Heard MS So-and-so. The Learned Counsel appearing for the state respondent. This application has been filed. Under Chapter 5, Rule 76, within bracket small d of the Gauhati High Court rules, praying for leave to file an appeal against the judgment and order dated 02/09/2025 in WPC number 166 of 2025. We have considered the submissions made by the learned counsels on all sides. The leave is granted to preferred appeal.
My lord.
With the aforesaid direction, the IS stands disposal.
Very well, my lord. Much obliged, my lord. And as far as the writ appeal is concerned, your lordship, there is another writ appeal which arises from the same cabinet decision, that is writ appeal number 25 of 25. So if both appeals can be clubbed together, your lordship, this appeal as well as the writ appeal 25/25. Your lordship, this is about steps taken by the state government to regularize the services of those healthcare professionals who performed COVID duties. Now, in the doctor's case, which is writ appeal 25 of 25, the learned single judge, her ladyship, allowed the petition. Against that, writ appeal has been filed.
Both the appeals shall be listed together.
Yes, madam. So both appeals should be listed together.
In item number 15, you write, heard Mr. A. G. Moni, the learned counsel appeal for the appellant. List this appeal along with writ appeal number
25 of 25.
25 of 2025.
Appeal may be admitted, your lordship.
First of all, the appeal has been then heard Mr. A. G. Moni appearing for the appellant. Who is for the other party? This is
For respondent 130 to 133.
Heard MS so appearing for the respondents.
130 to 133.
130 to 133. The appeal is admitted for hearing. Issue notice to the respondents. No formal notice is required to be sent to the respondents 130 to 132. 133. As because MS so has accepted notice, extra copy of the memo of appeal shall be provided to her.
Your lordships, if I may seek your indulgence, 1 to 129 by substituted service, your lordship, there are plenty. Personal service would be different.
1 to
129.
Notice upon the respondents 1 to 129.
Yes, madam.
Shall be served by substituted manner.
Yes, madam. In one local daily, your lordship.
By publishing the notice in a local daily newspaper. List this appeal after 4 weeks along with writ appeal number
25 of 25.
25 of 25.
Yes, much obliged, madam.
For orders, item number 16.
May I please, your lordships?
Yes.
Your lordships, in this matter, your ladyship's, the office held by your ladyship's husband is respondent party. However, if it will be possible to issue notice on the IA for condonation.
The single bench was by her.
No. Single bench order was by a different judge. However, your ladyship's husband is holding the office of the respondent party.
No, he is no more there. Okay, he has already left the office. Anyway, he issue notice can be issued.
The hard MS.
Ubang Ninla Longcha.
Appearing for the applicant in the IA. Hard MS.
S. Mary.
S. Mary. Appearing for the
Respondent 1, 3, 4, and 5.
1, 3, 4, and 5. Issue notice. No formal notice is required to be sent to the respondents 1, 3, 4, and 5.
Yes.
1, 3, 4, and 5. The petitioner shall take steps for service of notice upon the respondent number 2 by registered postage ID. List after 4 weeks. This list.